Good afternoon. Thank you everyone for joining. So today we are going to discuss supplemental needs trusts, which, just so you know, are sometimes referred to as special needs trusts. So this slide has a little bit of a background about me. I am senior counsel here at Tully Rinckey. My main practice areas are estate planning, trust administration, probate administration, guardianships, and estate tax matters. So I want to give a quick roadmap of what we're going to cover today. So we're going to start with the basics. So understanding government benefits, the limitations of supplemental needs trusts, types of supplemental needs trusts, how supplemental needs trusts protect benefits, what ABLE accounts are versus supplemental needs trusts, funding and practical considerations with these trusts. So what an S&T does. I'd like to start here because the whole idea of a supplemental needs trust can feel abstract until you know what it actually does. So a supplemental needs trust, or as I will refer to as S&T, is a financial tool that allows someone with a disability to receive money or support without losing their government benefits. Many benefits like SSI or Medicaid have strict income and asset limits. If the person receives money outright, even small amounts, they can lose those benefits immediately. An S&T can prevent that from happening. The trust holds money on behalf of the person with the disability. That money doesn't count as their personal assets, so they stay eligible for important programs like Medicaid and SSI. At the same time, the trust can pay for things that improve their quality of life, things that government benefits cover. So when you think of an S&T, think of it as a safety shield. It protects the benefits while still allowing the person to have additional resources and support. So in this first section, we're going to go over some of the initial consultation and client goals. So why the initial consultation matters. During the initial consultation, our main goal is to gather the information we need to determine whether a supplemental needs trust is it and how it should be structured. We talk about your goals for your loved ones, what assets you have, and how those assets are owned, because that helps us decide which type of supplemental needs trust makes the most sense. We also review who in the family has a disability, what support they need, and which government benefit or benefits they're receiving. That's critical because SSI and Medicaid have strict financial rules. And the trust needs to be drafted in a way that protects specific benefits. So, information we look for. We're going to ask you about your goals for protecting your loved ones with a disability, your financial picture, so that will be your bank accounts, any real estate, retirement accounts, etc. Existing legal documents, so wills, trust, guardianship orders that you already have. Details about the disability and the current support needs that they need. And we will also request confirmation of the type of benefits that that individual is receiving. So we may also ask for those official documents. So in this next part, we're going to go over Government Benefits 101. So there are two types of government benefits. And it is important to understand these main categories because they determine what kind of planning is necessary. So the first category is means tested benefits. Programs like SSI, Medicaid, Section 8 housing, and SNAP have strict income and asset limits. The second category is non-means tested benefits like Social Security Disability or SSDI and Medicare. These don't have asset limits because they are based on work history, not financial need. Understanding these benefits, which benefits someone receives, is critical to planning. If they are SSI or Medicaid, we need to create something like it, a supplemental needs trusts.
Darlene Snell.
Supplemental Security Income or SSI. So we're just going to go over here the type of limits that are on different types of benefits, starting with SSI. So who is eligible for SSI? This is anyone who is age 66 or older, an individual who is blind, or an individual who is disabled. SSI is generally for individuals who don't earn more than $2,019 from work each month. Couples and parents with children are typically granted more SSI. Your resources or assets should not be more than $2,000 for individuals or $3,000 for couples. So Medicaid. Medicaid is a program for low-income persons whose income and or resources are below certain levels. For individuals, income limit is $1,800 and the asset limit is $32,296. So Section 8 housing. This enables the lowest income households in New York to rent or purchase decent, safe housing in private housing market by providing rental and home ownership assistance. The program works as a rental subsidy that allows families to pay a reasonable amount of their income towards their rent. Eligible families will receive a voucher to begin searching for housing. Eligibility, your household income must be at or below 50% for the area median income for your family size. This 50% may change based on your location. So for example, in New York City, it is 30% of the area median income. So why this matters? It matters because means tested programs have a very strict financial requirement. If someone receives SSI or Medicaid, who receives those types of benefits, and if they suddenly inherit money, if they suddenly receive a settlement, or even have savings that go over the limit, they can lose those benefits immediately. For Medicaid, that could mean losing access to medical care, therapies, and services. For SSI, that could mean losing monthly income that they rely on. A supplemental needs trust acts as a barrier as it allows money to be set aside for persons without being counted against them. This is why we're so careful about understanding exactly what benefits are involved. So, common benefit confusion. One thing I see all the time is confusion about government benefits. And honestly, it is completely understandable. The programs have similar names and they all come with their own rules. So for example, SSI versus SSDI, they sound almost identical, but they work very differently. SSI is based on work history and, SSI is needs based and has very strict financial limitations, while SSDI is based on work history and does not have asset limits. People also frequently mix up Medicare versus Medicaid. Medicare is age and work based, and Medicaid is income based. So, why do we care so much about getting the distinctions right? This is because the type of benefit someone receives determines how we plan. If someone thinks they are on SSDI, but they're actually on SSI, and they inherit money directly, that can cause an immediate loss of benefits. So, Section 3, limitations of a supplemental needs trust. What a S&T can pay for. Now that we know what an S&T is, it's helpful to talk about what it can actually pay for. A supplemental needs trust is designed to cover the things that government programs don't. For example, Medicaid may cover basic medical care, but it won't pay for extra therapies, sensory equipment, private caregivers, or adaptive technology. SSI might provide a monthly benefit, but it won't cover things like clothing, furniture, vacations, or educational programs. And S&T can pay for all of those. It can provide internet service, a cell phone, transportation, dental care, or recreational activities that really enhance someone's life. It can also pay for professional services like care management or financial management. The key rule is this: the trust has to pay providers directly. The trust cannot pay the beneficiaries. So, what an S&T cannot do. While supplemental needs trusts offer a lot of flexibility and protection, there are some important limitations to understand. These limitations aren't there to make things difficult. They're there because government benefit programs have very specific rules. The most important rule, which I've identified prior, is that the trust cannot pay cash directly to the beneficiary. If the beneficiary or the person with a disability receives cash, even in small amounts, that can be treated as income and reduce or eliminate their SSI or Medicaid benefits. The trust also cannot make payments that are meant to replace benefits. So, for example, SSI is intended to cover basic food and shelter. If the trust pays for certain housing related expenses the wrong way, it can reduce your SSI payments. This is why trustee education is so important. The trustee doesn't have to be a legal expert, but they do need to understand what kinds of payments are allowed and what needs careful handling. Following these rules keeps the trust compliant and protects benefits long term. In this part, we're going to identify the different types of supplemental needs trusts. There's no one size fits all trust. In special needs planning, we have several different types of trusts. And the right one depends on whose money is being used and the family goals. So the main types of trusts are third-party supplemental needs trusts, which are funded with the family's money, usually a parent or grandparent. It can also, and then the first-party supplemental needs trust which is also called a D4A or a self-settled trust, is funded with the beneficiary's own assets, such as from inheritance or from a settlement. And then there's the pooled trusts, which are run by nonprofit organizations and are often used for smaller amounts or when trustee options are limited. And then finally, there's the testamentary S&T, which are created under a will and only come into existence after someone has passed. Each type of trust has their own rules, advantages, and restrictions. So the third party S&T, which is also the most common, this type of trust is created and funded by someone other than the person with the disability. Most often, it's a parent, grandparent, or a sibling. The key feature is that the beneficiary never owned the assets going into this trust. Because of that, third-party S&Ts are incredibly flexible. There is no limit on how much money they can hold. It could be 20,000 or it could be 2 million, and the beneficiary will still remain eligible for SSI or Medicaid. So another major advantage is that there is no Medicaid payback requirement when the person with the disability passes away. That means the family can decide where any remaining funds go, whether to siblings or other relatives or even to a charity. So for families planning ahead, this third-party S&T trusts can be an ideal structure. So first-party S&T, also known as D4A, this type of trust is completely different from the third-party S&T. A first-party S&T is used when the beneficiary already has assets in their own name. This often happens when someone receives a personal injury settlement, an inheritance that wasn't planned correctly, child support payments, or savings that have accumulated over time. To remain eligible for SSI or Medicaid, those assets have to be moved into a proper first-party trust. But first-party trusts come with very strict requirements. The beneficiary must be disabled under Social Security's definition. The trust must be set up before they turn age 65. And most importantly, the trust must include a Medicaid payback provision. This means that when the beneficiary passes away, Medicaid gets reimbursed for services it provided during their lifetime. Only after Medicaid is repaid can remaining funds go to family members. First-party S&Ts also require annual accountings and greater oversight, so they are more administratively demanding. So, pool trusts. Another option is a pool trust, which is managed by a nonprofit organization. Pool trusts can be either first party or third party, depending on where the money comes from. What makes them unique is that the nonprofit manages many individual accounts together, like a large group investment fund, but each person still has their own separate sub-account. Families often choose pooling when they don't have a good individual trustee option, the amount of money is relatively small, or they want professional management without hiring a private trustee. These trusts follow the same rules as other SNTs, but because they are run by nonprofits, administrative support is already built in. They typically charge though they do typically charge annual fees. For first-party pooled trusts, there is usually a Medicaid payback requirement, or the nonprofit may retain a portion of the funds at death, depending on the program structure. So the testamentary SNT. The last type that we'll cover here is the testamentary supplemental needs trust, and this trust is created by a will and only comes into existence after someone passes away. These trusts are commonly used for one particular situation, when a spouse wants to leave assets to their disabled spouse. Under Medicaid rules, a spouse cannot typically create a lifetime, otherwise referred to as inter vivos, SNT for another spouse without the assets being counted. But if the trust is created by a will, after the spouse passes away, the assets can flow into this testamentary SNT and will not be counted towards the surviving spouse's Medicaid eligibility. Outside of the spousal planning, testamentary SNTs are often less ideal than creating a trust during lifetime because they only become effective after probate. The estate has to cover the costs of getting trustees appointed. The court often appoints a guardian ad litem to oversee the administration, and it delays when the beneficiary can actually receive any support. So while a testamentary SNT can be essential for spousal planning, for other beneficiaries, we typically prefer an inter vivos trust, such as the first party, third party SNT, or the pool trust, which are established during the client's lifetime. So, Section 5, why SNTs matter. So, why not just leave assets directly? A question that I get from families all the time is, why can't I just leave money directly to my child or sibling? Wouldn't that be simpler? And it's a really understandable question. But unfortunately, leaving assets directly to a person with disability, either through a will, as a gift, or as a beneficiary on an account, can create serious problems. For someone receiving SSI or Medicaid, even a small amount of money deposited into their name can push them over the financial limit and completely disqualify them from their benefits that they have likely come to rely on. Beyond benefits, giving someone money outright can create other risks like financial exploitation, mismanagement, and pressure from others. A supplemental needs trust avoids all of that. It lets you leave support for the person without giving it directly to them. The trust protects their benefits and ensures the funds are used to improve their quality of life. So, government benefits typically provide for just the bare minimum. Programs like Medicaid and SSI are an essential safety net, but they only cover the bare minimum. Medicaid will cover basic medical needs, but it rarely covers things like basic, private therapy, adaptive equipment, etc. SSI provides typically roughly around $900 per month, which is not enough, which is can be just enough for rent, food, and transportation and daily living expenses. This is why families often feel worried about the future of individuals with disabilities. Even with these benefits, there is still a big financial gap between what the person needs and what the government program actually provides for. So, funding and practical issues. So, typical funding sources for SNTs can be bank accounts or investments, a life insurance policy, retirement accounts, which we'll talk a little bit more next, and gifts from grandparents and or relatives. So you can also choose to fund a trust now, fund it later, or fund it gradually. Some families set up the trust during life, but only add resources to it after they pass away through their will or life insurance or beneficiary designations. So, funding with retirement accounts. And this is kind of going into Secure Act 2.0. So, retirement accounts like IRAs and 401ks are typically restricted by an act. It's called the Secure Act 2.0. Normally, when someone inherits a retirement account, they're required to withdraw all the money within 10 years. That means higher taxes and a shorter time to stretch those dollars. But there is an important exception for individuals with disabilities. If the retirement account is left to a properly drafted supplemental needs trust, the trust can qualify as what's called an eligible designated beneficiary or EDB. Qualifying as an EDB allows an IRA or 401k to be paid out over the beneficiary's entire lifetime instead of just the 10 years. This is much more tax efficient and preserves the money for long-term needs. There are a couple key requirements for the SNT. The trust generally needs to be structured as an accumulation trust. That means the trustee can retain the distributions instead of paying them directly to the beneficiary. A conduit trust won't work for special needs planning because it requires the trustee pay income directly to the beneficiary instead of the trust retaining those assets. If you want to name a charity as a remainder beneficiary, that can still work, but it has to be structured carefully. So, ABLE accounts. What is an ABLE account? An ABLE account is a tax advantage savings account for individuals with disabilities. Think of it like a special type of bank account that allows someone to save money without losing their government benefits. There are two key eligibility rules for these types of accounts. One, the person must have a qualifying disability. And two, the disability must have begun before the age of 26, though that expands to age 46 in 2026, which will open the door for more families. ABLE accounts are great because they allow money to grow tax-free. They can be used for a wide range of disability-related expenses. They don't count against SSI or Medicaid unless the account exceeds certain limits. ABLE accounts are especially useful for small amounts like birthday gifts, work income, or small inheritances. And they give the person more independence since they can access the funds directly. Most families find that ABLE accounts and SNTs work best together, not as an either or. So, ABLE account limits. In 2025, there is an annual contribution limit of 19,000. That means up to 19,000 per year can be deposited into the account from all sources combined. There is also a lifetime or aggregate limit, which depends on your state. Here in New York, the total is 520,000. The account can keep growing towards that limit, but once the balance goes over by 100,000, SSI benefits may be reduced or suspended, although Medicaid will continue. Another important limitation is that the beneficiary can have only one ABLE account at a time. Unlike trusts, you can't set up multiple accounts in different states or for different purposes. Even with these rules, ABLE accounts are incredibly useful, especially for day-to-day expenses or smaller saving goals. So I've created a chart here that has a comparison of ABLE accounts versus supplemental needs. So with an ABLE account, there is a contribution limit. With an SNT, there is not. So with an ABLE account, there is tax-free investment growth. With a SNT, there is not. So with Medicaid payback, ABLE account, there is a Medicaid payback. And then with SNT, it depends on the type of trust. So if it's a first party trust, there is a Medicaid payback requirement. And then below there is who those plans are best useful for. So practical cautions and best practices. So first off, practical cautions. As we've discussed, never give cash directly to the beneficiary. Even small gifts can interfere with their government benefits. All support should go through the trust or the ABLE account. Second, be careful with housing payments. Some housing expenses paid by an SNT can reduce SSI benefits. It's not illegal, it just has to be done thoughtfully so you understand the impact. Third, trustees need to keep good records. Trusts require documentation for tax and benefit purposes, and proper accounting prevents issues down the road. Fourth, the trust should be reviewed under the laws of the state where the beneficiary lives, not just where the grantor lives. Each state has slightly different Medicaid rules, and compliance is key. These practical steps help ensure the trust stays effective and compliant, and they give family peace of mind that the plan will actually work as intended. So, choosing the right type of trust. It all depends on where the money is coming from and the goals of the family. If the funds are coming from parents, grandparents, or other relatives, a third party SNT is almost always the best choice. If the money already belongs to the person with the disability, the first party SNT is required to keep those benefits safe. If you don't have a good individual trustee option, or you're working with a small amount of money, a pooled trust through a nonprofit can be very practical and an affordable option. And for married couples where one spouse has a disability, a testamentary SNT created in a will is usually essential. So, key takeaways: SNTs protect vital government benefits. Trusts can improve the quality of life and long-term stability for a disabled individual. And the correct planning prevents disqualification for those government benefits. ABLE accounts are typically complementary to supplemental needs trusts and always confirm the type of benefit the disabled person is receiving. Thank you, everyone.